You're listening to the Subrogation Support Network, a podcast from Mattison, Wickert & Layer, America's subrogation law firm, with dissemination of new developments and changes in subrogation law, as well as emerging trends and best practices. Here's your host, Ashton Kirsch.
Hello, audience. Ashton Kirsch here, your host with today's episode of the Subrogation Support Network podcast. It's been a while. We've been running around like crazy and haven't recorded nearly enough, but we're back in the game. We will have monthly and bi-monthly podcasts going forward indefinitely, but sorry for the delay in this. Today, it is my honor and my pleasure to have one of my favorite guest stars join the podcast. Don Henderson is here, associate attorney with Mattison, Wickert & Layer, the premier subrogation law firm, litigating your subrogation matters in all 50 states. Don, how you doing today?
I'm doing great. Thanks for having me, Asher.
Excellent. So today we have an interesting topic. This is load shift claims in the commercial trucking context. We see quite a bit of this in work comp, in OCAC claims, and property, cargo, and so forth. So it's a really relevant topic for anybody who deals with commercial auto claims, cargo, or any drivers who may be having their vehicles flip over. So it'll be a good one today. Again, we are not going to give you the full presentation today. We're going to give you a snippet, a teaser, something that's going to convince you to say, hey, let's jump onto the MWL website next week and join Don. Again, that's Tuesday, July 22nd, 11 a.m. Central. I'll remind you again later. But Don, let's briefly jump into it. Tell us a bit about yourself. I know I think one of our last podcasts, we did kind of a bio of you and talked about being a new attorney and handling subrogation claims. But just give us a little reminder about who you are and what you're doing over with MWL.
Yeah, for sure. So as you mentioned, my name's Don Henderson. I'm an associate here at the Hartford office. Been here for over a year and a half now, actually closing in on 2 years. It's kind of flown by, honestly. And yeah, I'm a Milwaukee kid. I went to law school at Marquette and then ultimately graduated in May of 23 before joining MWL in December of 23 as well. As for the webinar next week, as you mentioned, it's on load shift accidents. I'll give a quick summary as to what that webinar will touch on. We'll mainly be focusing on how to pursue the shipper, aka the company that was responsible for loading the cargo onto the trailer or the truck. Basically going over how to pursue a claim that, the damages, whether it was property damage to the cargo itself or the other cargo that's present on the trailer, or, maybe the vehicle, or even an injury to the driver or another driver that's on the road, how to pursue the shipper for the damages that ensued as a result of them improperly securing the load. Again, I won't go into too much detail. We'll obviously go over a lot of the recovery avenues in the presentation itself, but basically trying to provide steps and suggestions on when we have a good claim to go up against the shipper as opposed to just allowing the carrier to be held liable for the damages.
We've done a few podcasts and episodes on cargo claims, how to subrogate cargo damages, right? Under the Carmack Amendment, COGSA, which is the Carriage of Goods by Seas Act, or even airway claims. The amount of cargo shipped around the U.S. is insane when you actually look at the numbers. This kind of turns that on its head because typically we're representing either the shipper or the damaged party, and we're pursuing the motor carrier for damaging the cargo. Usually there are load shifts quite often, but oftentimes we don't care on those cargo claims because it's strict liability under Carmack. So whether they flipped it over or they, somebody else damaged it or whatever it could be, the motor carrier is still responsible. But this is kind of flipping that around, and it's a different approach. This is where, hey, we are the motor carrier. Hey, our load did shift and our vehicle did flip over, jackknife, something occurred. Everything's damaged, the vehicle's damaged, somebody else is hurt. So it is kind of a unique approach where we're holding the shipper responsible for their negligence or their improper acts in loading that cargo. Now, Don, let's get some examples just for the audience because, maybe everyone doesn't deal with these claims because this is relatively niche. But what type of companies or insurance carriers would deal with these losses or be pursuing these claims or even defending these claims for that matter?
Right. So yeah, as you mentioned, we did a presentation yesterday to one of our clients that was occupational accident claims. We've done this for, just subrogation auto carriers in the past before. And then, even personal injury insurance carriers. And then any carrier who's representing an injured truck driver or, maybe the company, the insured that ultimately was employing the driver that was involved in the accident themselves. So as it relates to the driver himself or herself, their injuries would be included in these damages. The type of claim varies and can be pursued in many avenues.
And a side note for the audience, at MWL, there's different practice groups. I've managed our auto practice group for some time, and Don works under me with those claims. What's special about subrogation is that despite Don's been practicing longer than he's been with the firm, but despite us being with this firm, handling these claims for 2 years, he's had this ability to develop a profound expertise in this subject matter because it's really a niche within a niche, right? Or within a niche of a niche. And it's like Inception in a way. But it's the idea that, it's experts in subrogation, and then within subrogation, you have auto subrogation or OCAC or work comp. And then within that is this very unique idea of load shift claims. And there's some very fascinating law behind it, where it's not just true negligence rules. There's a lot, and we'll get into that briefly today. But I guess as an example for the audience, a case that I handle a couple of years ago was a mix. It was actually work comp benefits, and we also had the damage for the trailer. It was a self-insured trucking company. And what happened in that scenario was I was in Wisconsin. Our truck driver drove up to the dock, and the trailer was opened up, and the dock leveler leveled out, and then a forklift came on, and the shipper loaded numerous pallets of, canned tomatoes, large cans of tomatoes. What happened was those cans, there's a specific way that they should be loaded, and they call it staggered and tied down. So they should be to distribute weight. You have, basically one here, then diagonal to that is another diagonal, tied down, totally plastic wrapped, perfect condition so that it stays straight. And there's different ways to tie it down. They call it dunnage is what they use. Oftentimes it's like, they can use blocks, they can use wood, metal beams, they can use ropes, they can use cardboard a lot of times. Well, in this case that I'm giving you as an example, truck driver leaves. They actually didn't let him get on the dock to inspect. They just closed it up, and he went down the road about 6 blocks. He makes a very reasonable turn to the right to get on the highway. Load shifts, truck tips over. He's injured. Trailer's damaged, tractor's damaged, all the above. So in that scenario, what we ended up finding out is that the way they loaded it is they loaded this with everything on the right side. So they just toss it all in on the right side, put some blocks on the side, and then also they barely used any plastic wrap. So what happened here is the moment he took that right turn, the load totally shifted. It was immediate. And our claim against the shipper was, hey, you guys needed to load this properly. Okay, so there were some defenses there. They came back and said that it was our driver's responsibility to inspect and that it's not their fault. And that's what Don's going to give you some examples of soon. They also argued that, hey, if they wanted it differently, the driver should have told them to load it differently. Our argument was, no, you're the experts. And you also did give us the chance to inspect. We could have never seen this. So there's some very profound nuances there. And interestingly, while that seemed like a slam dunk case, there's some reasons why that case ended up resolving and settling. And one of those reasons was that ability to inspect. Our drivers should have been able to, if they opened the back of that trailer as it was their duty to do so, they should have been able to see that this was absolutely improperly loaded. They should have taken the cargo. So there's some steps here, but that's an example of how this kind of comes into play. Lots of different ways, lots of different parties. The shipper, quote unquote shipper, which is statutorily what it's referred to, could be the actual company shipping. It could be a warehouse. It could be a freight forwarder, a freight company, whomever it is. Wanted to give you an example. So again, this could come in the auto property context where we are insuring the vehicle, the tractor, we're insuring the trailer. It could come in the context of a case where we're pursuing a motor carrier and that motor carrier cross claims in a shipper. It could come in the situation of a work comp claim where we have the driver, or an occupational accident claim in the same regard, slightly different way that those policies look and our allocation rights. But it could be that our driver's injured in that situation. We're pursuing the shipper. Lots of different ways. And this actually happens a lot more often than you think. Back to you. Tell me, why is this important that the audience knows about these claims?
Yeah, this is super important because about a year ago, maybe just over, we were me and another one of the MWL team members were meeting with one of our clients, and we were just kind of going over some of these cases. And it came to our attention that there's a lot of load shift claims that our clients weren't previously sending us because they just kind of assumed that the responsibility fell on the carrier, which in a lot of situations it does. Right now, we're looking to spread awareness on these claims to see if there's probably a lot more claims that can be recovered from the carrier's side of the claim, that we're looking to expand our caseload on those and also create some more avenues of recovery for our existing clients and maybe future clients as well.
There have been several identification. I mean, that is probably the most important thing for the industry to really get right. And it's probably the primary thing that they're getting wrong. And that's that inability to just red flag a case and get it to subrogation. And this is such a relatively obscure and unique type of issue that I guess even if, first off, it's usually not being flagged by the first party or the frontline adjusters to get to subrogation. But also, if the subrogation adjusters aren't trained in this, they're not going to identify it either. I think that's largely also because, I mean, there's the FMCSA, and Don will tell you a bit about them. And one of those legal responsibility is that the motor carrier and driver, they are the one responsible for ensuring that the cargo is loaded and secured properly. A lot of times that is the immediate defense on these cases. And we just get a response saying, no, motor carrier is responsible. But that's really, sure, that's what the FMCSA says. And that's also largely how it relates to a third party. So if that tractor or trailer that flips over on the road and injures somebody, and then ultimately that motor carrier is responsible to them. That's largely what that's dictating. However, that doesn't necessarily mean that the shipper can't also be held responsible. I think that's something just to keep in mind of what is so important, because if we can identify these claims, maybe not all of them are recoverable, but it's just important to note that, there's more to it. They should be identified for subrogation, and we should be reviewing the case. Talking about those cases. Oh, go ahead.
Sorry, I didn't mean to interrupt you there, but yeah, I mean, you kind of hinted at it, but yeah, just being able to properly identify and flag these cases, throwing away good cases and sending over, referring to us bad cases. And we're looking to kind of correct that. And also, like I said, spread awareness on, what potentially a recoverable case would look like, and what essentially like, nope, this one is kind of on us, and, there's no point in pursuing. It would just be kind of a waste of time and resources. And so just trying to, fine tune that line and, create a little more knowledge on what cases should be pursued out the gate, and what cases should be kind of flagged as from the beginning as like, no, there's no pathway for recovering on this one.
Absolutely. Now, Don, put that professor hat on and give us a little bit about the law. What law applies to this? I mean, is this like a normal negligence case, or, I know the answer. I'm asking it as if I don't, but let's pretend I don't know the answer. And tell me a little bit about the law applying to load shift claims.
Right. You brought up earlier the FMCSA, which is the Federal Motor Carrier Safety Administration. They have federal regs that, are kind of the step one of the analysis, in my opinion, where they set out, regs. A big one, especially as it relates to what we're discussing today, is statute 392.9 of those regs, which goes over the driver's responsibilities before and during transportation. And so, the driver has many obligations and requirements that are imposed of them. If they're not meeting those requirements, then, liability can just be assigned to the carrier, regardless of what mistakes or defects the shipper could have created or allowed to occur. And so that's kind of, like I said, that's an initial starting point, making sure that the drivers are fulfilling their obligations and requirements under those federal regs. And then we get into some state specifics and case law rules. I believe we're probably going to touch on this a little more later, but you have like a majority rule and a minority rule for handling these cases, how the courts have kind of laid out their opinions and their decisions as it relates to making rulings on these cases.
Yeah, so tell me a bit about that. So when you say majority minority rule, what are those rules and what are you talking about?
Yeah, so the majority rule, which the majority of jurisdictions and states follow, is known as the Savage Rule. And that came from, I believe, a 1953 Virginia case. And the Savage Rule basically says that, similar to the FMCSA regs, that the motor carrier is primarily responsible for these accidents. And it says that the motor carrier is the last line of defense as it relates to inspecting and making sure that the load is properly secured and that it is ready for transportation, which again, that's the majority rule. On its face, it's primarily the carrier who is held liable for these accidents. However, the Savage Rule did create 3 exceptions for when the liability can shift back to the shipper. The first exception is when the defect created by the shipper is known as a latent defect. Latent is kind of a legal term, but it basically means concealed or hard to discover from just observing. If the defect created by the shipper is latent, then that meets the criteria for the first exception. And the latent test is also, there's a reasonableness standard that's associated with it. So basically, would a reasonable carrier or driver be expected to know that the defect exists and is present upon a normal inspection that they're required to do under FMCSA requirements? So that's the first exception. The second exception is the load sealed? And now, again, all of these there's contents and there's nuance that's added to all of these. But the second exception is the load sealed? And if the load is sealed, if the carrier is not able to physically inspect or examine the load, then there's no way that they are able to determine if there's a defect that is present or not. And if they're not able to determine that, then there's no way that they would have been able to prevent the accident from occurring. Now, there are situations where the shipper will inform the carrier that the load is sealed, but they're able to unseal it in order to perform their inspection. If that's the case, the driver still has the responsibility to making sure that the cargo is secured and in place during transportation. And the third and final one is that the carrier was given assurance by the shipper that the load is safe and secured and that there's basically no concern during transportation. Now, assurance is kind of a broad term, but the courts have distinguished just common language like, hey, you're good to go, or it's ready for you to begin driving, or something simple like that, which is just plain language letting them know that they're done with the load, versus something a bit more meaty, which is like, hey, the load is secured. You should have no problems. Everything's great. There's no issue, no need to inspect, things like that. That's the level of assurance that the court is requiring to meet that third level of exception. And so, again, that's the majority rule. And, there's a lot of room to argue and litigate over if an exception is met or not. But that's the majority rule. And then the minority rule is pretty simple. It's for the comparative states, the comparative negligent states. And basically, you just compare the negligence of the shipper to the negligence of the driver. And courts will use that to dictate how much of a recovery, or if there's a recovery at all, for the carrier. And so that one's a little more straightforward. The states that don't follow the Savage Rule, as I mentioned, are more so the comparative fault states.
Yeah. So under the majority rule, under the Savage Rule, those states, it's interesting to think about how that comes along with an individual claim. Like, for example, I think on the first exception, the idea that it was a latent issue, right? I think that some examples would be, and you don't know for sure, it's a factual issue. We need to go through the facts in depth on each specific case. But let's say the example I gave earlier about the tomato cans that are loaded to the right in a straight line rather than staggered. In that situation, assuming your driver was given the opportunity, even if they had to pull forward and look, they should have pulled forward and looked. But let's say they were to open that trailer and look, and then they could easily see that was to the right. And then you'd assume if a reasonable driver should have been able to look at that and say, oh my God, that's going to likely flip. Then they would have been precluded from bringing that, from winning on that claim. Arguably, still, there's a factual debate over that. However, let's say that it's only loaded to the right at the front end, but then on the back end it was staggered. That driver could have never seen from their vantage point. That's a different story, right? There's a better chance that they can argue that was latent. Or let's say it was a situation that I've handled a bunch of these where it was loaded correctly, but the pallets were not plastic wrapped and shrink wrapped properly. In that situation, would a reasonable driver have been able to look at that and say, hey, there's only 3 wraps of plastic. There's not the 15 that should be on there. And in that situation, in so many of those cases, what happens is they are palletized properly. The issue is not wrapped properly. So then the cans, after just some minor shaking and movement, start coming loose, start falling all over. Now you have a whole bunch of cans in a trailer. And when you have a turn, they all move to one side. They don't stay in place. Load shifts. So I mean, there's a lot of different ways that this applies under the Savage rule, but I think that's pretty fascinating.
And also to touch on that too, like there's like an objectiveness and a reasonableness that is associated with the drivers on this. I've seen cases where the court has decided, based on the driver's experience and their familiarity with the products and the material and the equipment that's being used to secure the cargo. I've seen cases where the court has said, based on all of that, the driver could not have been expected to know that the defect was present. And I've seen other cases where it's the same type of equipment used to secure the load that this driver has used for dozens of years. And in those cases, the court has said, nope, the driver should have known that the load was not secured. And so it's, like I said, there's a reasonableness and an objectiveness that's associated with these cases that basically ultimately comes down to how should that driver have known that the defect was present? And, that answer could simply determine if there's a recovery or not.
And discovery can get extremely complex on these cases because a lot of times the defendant's going to come forward and ask for all training manuals, any training that driver received and so forth. And quite often our insured or it's a self-insured, frankly, they don't want to produce that, especially on a case where they try to keep that under wraps because it's trucking companies. They could get a $90 million verdict next week and they don't want all this out here. So it does get complex and it does sometimes cause our clients to maybe be more hesitant to pursue these cases because once we get into it, that becomes truly at issue. So we can't really avoid production of safety manuals, training materials, and so forth.
Exactly.
I think the third exception you mentioned was kind of that verbal statement. I think that's kind of fascinating. And there are going to be people in the audience here because we represent a lot of trucking companies who are with trucking companies. What should they be telling their drivers over, I think, that verbal statement side of things? And, anything else that you'd say if you're talking to a trucking company, telling them what should they do to ensure that any claim is preserved and also that they avoid load shifts? What are your thoughts?
Yeah, I usually recommend, and I usually say on the onset that I understand that this isn't typically the typical driver's MO, but it is very important especially as it relates to recovering on these cases and making our job a little easier. Drivers need to take a detailed log and report of exactly what was said to them by the shipper or exactly what they saw during their inspection. And that includes even if the inspection didn't reveal a single thing. It's often the case that when they inspect, the load does appear to be secured because we have an easier time arguing that it was a latent defect if we say our driver did conduct their inspection and it appeared that everything was secured. If you don't have a log of the inspection, then it becomes a little more difficult. He or she inspected the load at this time, or it could have been this time. It's a lot more difficult to create that timetable and to show that the inspection was carried out and done properly without the log. And again, that goes the same with the exception that you're touching on, which is the assurance. If you make note of what the shipper said to you before you begin the transportation, the process at least, if you have a log of what was said to you, it's a lot easier to use that to hammer down the point that the shipper provided this assurance. If you don't, and if we're just going off memory, that can still come up in a deposition or something like that. But it turns into a lot more of a he said, she said, versus if we have that written log that we can use, it provides a little more basis for arguing that exception is present.
So the log's important, a verbal confirmation that it's safe, secure, and ready to move. I think something else that's important that you had mentioned to me yesterday was also pre-trip inspection. And the idea that, I've had a bunch of cases where the defendant comes back, the shipper comes back and says, well, there wasn't an issue with the load. The trailer was wonky, or there was some issue with the support beams in the trailer, and this wouldn't have occurred but for an issue. Is it important that and I know that most truckers do inspect the trailer, inspect the tractor before there's a whole checklist that they have to perform before they go and pick up that load. But is that really important here too?
Yeah, I mean, there's a reason that these cases are a little difficult to recover on. And it goes back to what the courts have said, which is that the carrier is the last line of defense between the load shift actually occurring, even though it's the shipper that's responsible for loading the cargo. What you're getting at is correct, that the pre-trip inspection is very important too. And there's regs from the FMCSA that touch on that as well. Ultimately, when the cargo is loaded into the trailer, the driver does have the responsibility of examining the cargo before even beginning the transportation process. Once the shipper has loaded the cargo, the driver is expected to examine it and make sure that everything is set to go. And if they have any questions or concerns, they're supposed to bring those to the shipper before the wheels even start moving. During transportation is very present, but also before, which is what we're talking about. And it's the latency component of it also begins with the pre-trip inspection. A truck driver can only really speak on or discover what they know. And so there's that, but yeah, they are expected to inspect prior to the trip. And now there are some cases, which we'll touch on in the webinar, where the shipper kind of instructs the carrier to not be present or participate in the loading of the cargo. Some shippers have rules about it's only their team, or they want the truck driver to wait either in the vehicle or in a waiting room or something like that. And in those cases, the courts have said the carrier is absolved from, their liability as it relates to the actual loading of the cargo. Now, they still have their duties to inspect, but if over the course of while they're waiting, the shipper comes and tells them everything's set and it's sealed, or, things are secure where they are, and that the carrier is unable to inspect or to examine the load from where they would be able to open the trailer and view into the back of the trailer, then that could be something that we use. And again, it's important to log that. But in many cases, the carriers are often watching the shipper load the cargo, or, helping out when they can. And if that's the case, I'm not saying that it's impossible to recover, but it does make it more challenging if they actively participated in the loading themselves.
Right. And if the load doesn't appear to be stable, if there's any issue, then that driver, that carrier, as we call them, they need to just say, no, I'm not taking the load. You guys need to figure this out.
They need to make it very clear to the shipper. And again, if there's even something that they're like, it could work, could not work, then they need to have the shipper do a better job of securing it. Because ultimately, the fact of the matter is, if they noticed it and they decide to drive and an accident does occur, it's going to be near impossible to convince the court that the shipper is responsible. That's kind of my issue with the latency component of this rule, because in my mind, it's the court saying that the bigger the mistake the shipper makes, the less responsible they are for what occurred. If they make a small mistake and it's something that's basically unnoticeable, then they're held liable. If they make a big mistake that someone else should have noticed, then it's the driver's responsibility. So why is it the case, in my mind at least, the bigger their mistake, the less responsible they are for what occurred? And I think that that's not necessarily how things are judged in the real world, but it is for these particular types of claims.
All right. So to put you on the spot here, here's an example. I'm going to come up as we're sitting here. So Joe Lumber is a truck driver. He's going to pick up a load, and he's loaded up with a bunch of large wood beams, and they're strapped down. It's an open trailer. He then gets loaded, takes off, load shifts later on. How do we typically vet those cases? You're getting one of those, and that's really all we know at that point in time. We don't really know much else. What should the carrier be doing? What should the insurance carrier, the adjuster handling the subrogation claim,
right,
what should they do next? Like, what are their next steps in figuring out if there's any subro potential here?
Yeah. So an immediate first step. Now, again, this one is kind of dependent on how much damages are involved and things like that. But if the claim amount permits it, then retaining a forensic engineer would be a good first start to have them investigate as to why the load shifted to begin with. That's a really good first step. But also just, getting the driver's logs, getting their notes on picking up, when did they pick up the cargo? What did they observe? What did they see? Things like that, talking to the driver, because as we know, I don't think that there are many drivers that are providing detailed synopsis on their logs. I think that those are pretty straightforward documents. If that's the case, then maybe you want to talk to the driver. Maybe you want to read those logs. Maybe you want to see if there's any pictures of the accident post or pre-accident. The driver did his job to inspect and he didn't see anything, then refer it to us and have us take a look, or talk it over with the engineer that you retained. And they may tell you that based upon what they're seeing, the driver, they were within the permitted speed range for the FMCSA's regulations, or they would have had no way of knowing that the tie downs were pulling apart as the car was in motion. There's a lot of avenues for finding out that the shipper actually created the defect and then ultimately pursuing the claim.
Absolutely. Now, we have a whole podcast episode about becoming an expert in selecting experts. But when we're hiring an expert, I feel like this would be even more unique. One of my big pieces of advice for our clients is, well, frankly, it's a big loss. Just get it to counsel and let us pick the experts. But one part of that is because we want experts with a specific subject matter expertise. A lot of these big engineering firms and a lot of these companies are going to say, oh yeah, a fire is a fire, an explosion is an explosion. It's a water loss. I've dealt with plumbing issues before. More than anything else, this would be one of those types of cases where we need the right person, be it a reconstructionist or somebody who not just any accident reconstructionist, not just any forensic expert, but also an expert that deals with load shift cases, because it's not just that they need to recreate the accident. They also need to be able to speak to industry standards and so forth. So Don, tell us a bit about, what you do if you're vetting an expert and trying to hire somebody to handle the case.
We're looking for maybe a reconstructionist, someone like that. We actually yesterday worked with an expert who is also a commercial driver. And so obviously that's probably going to be a rarity, but that helps a lot in these cases. Someone that's also familiar with the driving and the practicality of it. How is this actually taking place? And so, like I said, forensical engineers, someone who can basically tell you exactly how much weight the securement protocols had to support of the cargo during the transportation, things like that. And it sounds expensive, and it can be, but it actually goes very far in terms of actually making a recovery, because in a lot of these cases, if it's going to be disputed, which it likely is, you're going to need an expert that basically says, our driver did everything he was supposed to do, and this accident occurred because the shipper used improper tools or equipment, and regardless of what the driver did, the load was going to become unsecure at some point in the transportation.
Now, aside from retaining experts and so forth, do you have any other advice or guidance for insurance carriers who are investigating and pursuing these matters?
Yeah, just try to get as much info from the scene as possible. You can talk to the driver, try to get an over the phone interview or anything like that. But if you can get pictures of the accident, see kind of what broke, what equipment failed, something like that, any type of idea to pinpoint where the defect took place. Why did the load shift? And sometimes the driver may know. Sometimes it may become apparent from the photos. There's many ways to figure out how the accident occurred. The sooner we can figure that out, the better we can start to plan for how to proceed.
Absolutely. Any advice that you have for the actual shippers? Because subrogation claims come in many forms. So let's say we have a shipper who's trying to avoid these, or even a shipper who's bringing a claim against the motor carrier, which is probably subject to CARMAC. However, sometimes it isn't if it's intrastate, so within one state. But if you're advising shippers on what they should do, what's your recommendations for that?
I would just say, not just this one, but don't do any more than what you're required to do. In a lot of cases where shippers can get themselves in trouble is, we talked a little bit earlier about the assurances. If your job is to just load the cargo and tell the motor carrier when it's done, then, just do that. But the idea of saying, everything's secured, you won't have any issues, things like that, things that go beyond the normal scope of just loading the cargo and instructing the carrier when it's done, all that could do is create the third exception to the savage rule that we discussed earlier. So yeah, just looking to avoid any extra assurances that are provided to the carrier. And then also, making sure that while the carrier is doing their inspection, the shipper's also doing another inspection of the cargo. Obviously, they think it's complete once they tell the carrier that the job, that everything is loaded. But it doesn't hurt to take another walkthrough with the carrier. And, if maybe they won't have a question, but you'll see something yourself and you're like, maybe we should, tie that one down once more or something like that. There's, the sealed, making sure you're going over what items can be inspected and what items are just required to stay sealed. The more detailed instructions they give to the carrier about what their responsibilities are, what they'll have to take a look at, the more they can absolve themselves of the responsibility.
Right. Because if so they call it either shipper's loading account, they call it a sealed load, where basically the motor carrier, the carrier shows up and they pick up the cargo and it's in a container and it's in something that is sealed. And that doesn't always even mean it's locked, but they use a specific seal on there with a serial number that can show that if that is cut or taken off, that they'll know that. And actually the load will then be rejected by the consignee or whomever it's going to, the warehouse at delivery. Because, for food goods, for other things that, you can't have anything get into, that is incredibly important to protect that chain of custody. So I think what you're saying, Don, is that if it is a sealed load, then the shipper has a lot more responsibilities there, right? They can't just go to the motor carrier and say, hey, you were responsible. It's your fault because you're the motor carrier, right?
Yeah. If it's a purely sealed load, meaning that it isn't meant to be opened or examined or modified or anything until it is delivered to the place it's intended to go, then the carrier there's not really much examining that they can do because the load itself is sealed. And so when that's the case, the shipper is more responsible for making sure things don't shift or nothing happens over the course of the transportation. But again, there are some case law out there that says that some sealed shipments are still meant to be examined and just resealed. But if it's the case that like, nope, this is cargo that's sealed, do not touch it until it's delivered. If that's the case, then yeah, the carrier's responsibilities are a lot less burdensome in those situations.
Excellent. Now, one thing as we wrap this amazing topic up has gotten me thinking, and we didn't even talk about this yesterday. So again, I'm putting you on the spot with an issue, but it's the idea of autonomous technology in vehicles, which I speak a lot on. I just did a training on a few weeks ago at a conference. I'm speaking on 5 or 6 times this year. I think we're taking a leading role in pursuing autonomous vehicle manufacturers and operators for use of autonomous technology. And it's on the roads like crazy. I was just in LA for some meetings last week, and I saw at least a dozen of the new Waymo vehicles just driving around. You just see them in traffic. I saw one turn right in front of me and it waited for me to cross the crosswalk, and there were no drivers. There was just a vehicle driving on the roads on a busy street. So it's there. That's getting into the trucking context, where there's a couple trucking companies who are actually experimenting in Texas with fully autonomous trucks, which I'm kind of fascinated by. Obviously it's going to kind of change things if that becomes heavily implemented, because there's no longer a driver to inspect anything, right? It's just going to pick up the loads. Obviously in those situations, I'd imagine it's going to be exclusively sealed loads for at least the beginning, because otherwise, somebody could just get into the cargo and you'd never know when there's no driver to keep an eye. But yeah, it's going to be fascinating. I think that's going to be something in like 2 years, you and I are going to have to get back together and talk about this again. It's going to change a lot of things in trucking.
But I'll tell you, I think that once we are fully immersed into that world, there's going to be probably a lot more responsibility on shippers to make sure things are properly done on the outset. And so there's going to be a lot more shipper liability to go around, I think.
Yeah, then imagine at this point in time, the motor carrier needs to work with the shipper and get their approval to send some driver without a driver over there. But right now, I think it obviously would fall on the shipper largely, because they would have loaded it. Nobody would have been there to inspect it because they'll have other arrangements. But in the future, let's say that becomes common, it then would actually revert back to the carrier, because if they're the ones that are going to decide to send a truck with no driver, then they're going to also have to have sophisticated trailer technologies that can monitor the load, which is very possible, just not feasible given the price of transport. Anything else you want to add about the topic of the presentation before we sign this one off?
I'd probably like to touch on, again, the presentation next week is going to be in a lot more detail. We're going to go over some actual examples of how to win on both sides, whether you're the shipper or the carrier. And ultimately, we're just going to have a little fun with it. We're going to spread some information, but the goal of it is to basically get a better idea of what cases have been probably being thrown away by the insurance companies when, there's a pathway to recovery on some of them. And then ultimately to save time on the other end of that spectrum, which is cases that probably have been being, pursued, but ultimately there's really not much of an avenue to recover on. And like I said, we're going to have some fun with it. We're going to do it next on Tuesday, like you mentioned, at 11 a.m., July 22nd. It's going to be about an hour-long presentation, but you'll come away from that with a lot of information and also a lot of examples on what a win looks like and what a loss may look like as well.
Thanks, Don. Well, everyone, make sure you attend that webinar. It's going to be great. We've already had hundreds of people sign up. So there's, unlimited room though. So we could have thousands. If all of the thousands of people listening to this podcast can join. I did have numerous people actually reach out and say, hey, is the podcast done? Are you still doing this? And that really got me motivated. So I'm almost happy I took some time off because, people are listening and I think that's great. But with the podcast,
we're back, baby.
if there's any topics that you as the audience can think would be great to discuss, right? I mean, we're trying to focus on subro, but really anything insurance and claims related or even litigation related, let us know because we're always looking for good content. We're always looking to go forward. And I think that it would be fun to have some audience involvement with that. Or if you're listening, you're like, hey, I'd love to get on the podcast and talk about this issue. You're in the industry. Let me know. I'd love to have you on. Thank you, audience. Thank you, everyone, for attending. As I always say, because I do truly appreciate you all. But I will also say that, we did a podcast recently and we ended with some tech talk. So we did a podcast about AI technology and the use and the smart use of AI technology. And I mentioned the Stuno app that creates songs. So while Don was talking about 30 seconds ago, I put a quick prompt into the app because I want to have a closing out song for all of us to lead the podcast today. So I asked it to make a song about shippers and, bringing a claim against shippers and so forth. It was like a 3-sentence prompt. So I haven't listened to this yet, but in signing out, for those of you that want to stick around, let's listen to a song called I'm in Love with a Shipper.
I saw her at the dock, stacking up the freight. Boxes leaning sideways, yeah, it sealed my fate. She smiled and said it's loaded, go ahead and drive. But the trailer wobbled like it came alive. I'm in love with the shipper, oh no, she's a flipper, tip my truck, I'm stuck. And now I'm feeling bitter. She says it's on me, cites the savage decree. But that load was sneaky, how could I foresee? Latent defects lurking, hiding in the stack. Straps look fine, but the weight fought back. I hit the road, then the world went round. Cargo chaos sent me crashing to the ground. She says, driver, check your trailer tight. But some dangers stay out of sight. Whoa, I'm in love with the shipper, oh no, she's a flipper, tip my truck, I'm stuck. And now I'm feeling bitter. She says it's on me, cites the savage decree. But that load was sneaky, how could I foresee?